The Arusha branch of International Residual Mechanism for Criminal Tribunals is now in session.
Will you please call the case?
Good afternoon, Your Honor. This is case number MICT-18-116 in the matter of the Prosecutor versus TURINABO et al. Sitting today, 14th March 2019, for a status conference in this case.
Thank you, and good afternoon. I'm Judge Joensen, the single judge assigned to this case. May I now please have the appearances of the parties. First, the prosecution.
Good afternoon, Your Honor. The prosecution is represented today by myself. I am Tembile Sokhwete. I am the acting senior legal officer in the OTP and also officer in charge of the Arusha branch of the OTP. I'm sitting this afternoon with Mr. Rashid Rashid. He's a legal officer and also team leader of the prosecution TURINABO team. We are sitting with Ms. Stavrola Papadopoulos. She's also a legal officer in the OTP. We have Mr. Joshua Rosenzweig. He's also a legal officer. And we have Ms. Irene Bully, our case manager. I thank you.
Thank you, Madam Prosecutor. And now the defense, starting with counsel for Maximilien TURINABO.
Good afternoon, Mr. President. I'm representing Maximilien TURINABO, who is present in the court this afternoon. I am Stéphane Bourgon. I'm from Montreal, Canada. Thank you, Mr. President.
Counsel, and now counsel for Mr. Anselme NZABONIMPA.
Good afternoon, Your Honour. Jeffrey Roberts on behalf of Mr. NZABONIMPA.
Thank you. And counsel for Mr. Jean de Dieu NDAGIJlMANA.
Good afternoon, Mr. President. I am Philippe La Rochelle from the for Dieu NDAGIJlMANA. Thank you.
Mr. Marie Rose FATUMA.
Thank you, Mr. President. I am Gatera Gashabana, an advocate with the Rwandan Bar, and I'm representing Marie Rose FATUMA. Thank you, Mr. President.
Now, counsel for Mr. Dick Prudence MUNYESHULI.
Good afternoon, Your Honor. Kurt Kearns appears on behalf of Dick MUNYESHULI. We also appear with legal assistant Laura Luca and legal consultant Dragan Ivatic. Thank you.
Thank you, counsel. I would like to remind the parties that certain information in this case is subject to protective measures and confidentiality orders. This includes confidential information that has been redacted from the indictment as to the identity of certain individuals and the basis for the review proceedings in the Engabatoire case. Confidential information should not be disclosed in open session. To the extent a party is required to refer to any confidential information, you must first indicate the need to go into private session to ensure appropriate measures are taken to prevent public disclosure of confidential information. The initial appearance of the accused was held on 13 September 2018, and the first status conference occurred 92 days later on 30 December 2018. Today's status conference is being held in accordance with Rule 1669A, which requires a status conference to be convened within 120 days after the last status conference. The purpose of a status conference is to facilitate the exchanges between the parties so as to ensure expeditious trial proceedings, to review the status of the case, and to provide an opportunity for the defense to raise issues in relation thereto, including the mental and physical condition of the accused. Before we continue, I would like to briefly recount the main procedural developments in this case since the last status conference. On 8 February, I issued a decision dismissing Mr. MUNYESHULI's request for provisional release to the United States of America on the basis that he could not demonstrate that he would be entitled to enter and remain there, or that he could ensure his return to the mechanism for trial. On 18 February, I also dismissed Mr. MUNYESHULI's request to squash the sole count in the indictment charged against him, based on circumstances surrounding his arrest and the search and seizure of items from him. I further order that the material seized from him during his arrest be provided to the prosecution, but I state this decision pending the outcome of its appeal. In addition, this week I issued 4 decisions. It follows from these decisions that the prosecution has the authority to conduct this case, that it may proceed against the accused for the crime of incitement to commit contempt, that it may not charge the accused with contempt through their participation in a joint criminal enterprise, and that the prosecution must provide additional specificity in the indictment within 2 weeks. As the parties know, on 17 February, I issued a confidential decision ordering the registrar to seal and maintain any material seized from the accused during a search at UNDF. I also requested submissions from the parties on the search and seizure and possible modalities for reviewing these items for privileged material. I have received submissions and related motions, and I will adjudicate these matters in due course. If I require additional information, I will seek further written submissions. There is also pending litigation before me related to the harmonization of witness protection measures, seeking disclosure from the prosecution, and a request from Mr. NDAGIJlMANA seeking a stay of proceedings. Decisions on these matters will be issued in due course. I would now like to briefly go into private session to mention certain matters which are currently still confidential. And for the information of the public, going into private session means that we will cut the sound. You are free to stay and to watch the proceedings, but it will be without sound. And we will later return to open session. Madam Registrar. We are now back in open session. I appreciate the ongoing cooperation from the parties in relation to the issuance of a draft work plan setting deadlines for trial scheduling. In view of the intervening circumstances, including the appointment of a new counsel and the need to amend the indictment, a revised draft work plan will be circulated to the parties for their views in due course. And now I turn to possible procedural matters that the parties want to raise. Are there any other procedural matters related to the case that a party wishes to raise before I move on to the health situation of the accused? I will first give the floor to the prosecution, and then I will ask the defense to include any comments they might have when they get the floor to raise their own issues. Madam Prosecutor. Or Mr. Prosecutor.
Yes, good afternoon, Judge. On our side, we don't have anything to raise at this particular point.
Thank you. And now I give the floor to each of the counsel, and then at the end of their submissions, I will give the floor to the prosecution to respond to all of their submissions. First, I turn to counsel for Mr. TURINABO.
Thank you, Mr. President. We do have certain submissions to make this afternoon. Although some of these topics were discussed in more detail yesterday, we believe that it is important to have them placed on the record. Mr. President, the main issue I would like to raise this afternoon is that of trial preparations and the ability of the defense to prepare for the upcoming trial. We welcome the decisions rendered by the single judge, which will be of assistance in really speeding up things, and especially getting the new indictment within 12 days. We also welcome the fact that we did attempt to have a first cut at a calendar, which unfortunately is no longer possible, both for technical reasons, but also for state of preparation reasons. And that, to me, Mr. President, is the important issue, because from a state of preparations point of view, unless things change, the way they have been developing over the last few months, it is unlikely, Mr. President, that we will be able to begin this trial before the end of the year. And we would like to avoid this in many ways. The first issue I would like to bring forward, and that is, of course, the main issue, is that of the prosecution's attitude and cooperation towards trial preparations. Mr. President, this will not be a surprise to you. There's been ongoing discussions yesterday. I will not go over everything that was discussed, but I will say that we are now getting material which we requested long ago, which was refused when we initially requested the material. And I simply say that respectfully, that had we received this material earlier, it would have been a different, maybe, calendar today. I will not give any examples. Those were discussed yesterday afternoon. We do have still major difficulties due to the redactions applied to the material. I understand, Mr. President, that there are filings before you addressing the issue of redactions, but it is our understanding that these redactions should and could have been lifted much earlier. And right now, we are in a difficult position to work. And I respectfully say, in the same position we were in December, having to look at statements which are, for the most part, redacted. Third issue is we have some difficulties with the protective measures. This is all before you, Mr. President. I'm not going to say more. We look forward to having rulings and orders issued by yourself so that we can understand what it will be possible for the defense to do in approaching potential witnesses for the defense and potential witnesses for the prosecution. The fourth issue has to do with access to information. We are still, that it's a matter pending before the appeals chamber, we understand. However, what we wish to bring to your attention, Mr. President, is the fact that in our respectful submission, the prosecution maintains a position of sitting between two cases where it has access to all the information, but the disclosure of information is being on a selective basis, and not everyone is getting the same disclosure, not only in terms of the two cases, but even inside this own case of Mr. TURINABO, we are not all getting the same disclosure, and this is impeding our ability to prepare for trial. This was my main issue, Mr. President, and I respectfully, and I can look at my colleague and he can respond saying that he's been doing everything he can. We say that things are not working presently. The second issue, Mr. President, is that of the ability of Mr. TURINABO to prepare his case inside the UNDF. Further to the situation which took place on 7 February last, Mr. TURINABO does not have any equipment, any electronic equipment to prepare, and that issue needs to be addressed as a result of the ongoing litigation related to the search. We simply ask, Mr. President, that in the meantime, it would be appropriate, we suggest, for Mr. TURINABO and the others to be provided with some common electronic equipment so that they can proceed with working on their case. My next issue, which I will be very brief because I think it will be raised by my colleagues, is that of telecommunications evidence. Many motions are pending on the issue, but this, Mr. President, it's a major issue, and unless things change with respect of getting the necessary material, allowing us to file the appropriate motions at the appropriate time, then this is likely to delay the trial, which we know is already going to be delayed. And the last observations I wish to make, Mr. President, is that of provisional release. Trial date, we looked at dates during the preparation meeting yesterday. I guess some people might propose some dates, and Mr. President, you said that a new calendar will be issued shortly. The later we go, Mr. President, I respectfully submit that this has an impact on the provisional release requests which are pending before you. Thank you, Mr. President.
Thank you, Counsel. Did you raise the issue of new common equipment in the prison with the registry?
Yes, Mr. President.
You did. Okay, thank you. And I now turn to Counsel for Mr. NZABONIMPA.
Thank you, Your Honour. I'll simply try and be as brief as I can. Obviously, firstly, I would fully support and second everything that my learned friend has just said. We are facing similar disclosure issues with the prosecution. We raised this in detail yesterday. I'm sure those messages get through to you, so I see no point in rehashing them here. I would merely state for the record, as I did yesterday, whenever a disclosure request does go over to the prosecution and they are going to refuse it, they do so as soon as possible. And when I say as soon as possible, I mean within 2 days. I practiced at the SDL in a very, very long trial, and the only thing that made disclosure work was when there were concrete, definite deadlines for the prosecution to respond to disclosure requests. Because, with all due respect to my colleagues on the other side of the courtroom, unless there are such deadlines, their minds don't seem to be concentrated towards the defence requests, and they seem to sit for a very long time. And especially when the answer is no, the answer can be given straight away. That allows us to then seize you, litigate it, and move on. Otherwise, as my friends have said, we are not going to be starting trial for a very long time. And secondly, just very briefly on the issue that my learned friend just raised then, in relation to the liberty of my client, without obviously going into any details, I would suggest that the decisions you rendered this week exponentially increase the justification for provisionally releasing him with immediate effect. The indictment that is now operative, or will be operative within 2 weeks when the prosecution files it, is significantly less than the indictment that was confirmed last year. The maximum sentence, as a consequence, I would suggest, that could ever be imposed on my client for those facts, those allegations, is therefore also reduced. As a consequence, this is a necessary and relevant factor that should be taken into account when making that assessment, and I would obviously urge you to do so as soon as possible. I am fully aware that you're waiting, I believe, very soon for opportunities to be given for submissions by interested states, but in light of that, I would strongly urge and request a decision be issued as soon as possible thereafter. But apart from that, apart from seconding fully the submissions made by Mr. Vagn, I have nothing more to add at this stage.
Thank you, Counsel. And I now turn to Counsel for Mr. NDAGIJlMANA.
Thank you, Your Honor. I will try to be even shorter than Mr. Roberts. I will not repeat what he has said. I think the issues that have been brought home by my colleagues are all valid. I just want to bring home the fact that we're here to discuss effective and expeditious trial preparation. How do you prepare for a trial? You read the evidence. I was so surprised when I got to the UNDF, as you know, I've worked here for several years, to see my client arriving in this little booth with no material whatsoever. Nothing. Not a piece of paper, not a computer, nothing. So he has no effective means to understand the case against him. And as you are aware, to understand the case, there's a mix of factual elements that only the client can provide the lawyer, and then there's a legal work and common analysis which allow eventually the counsel and his client to effectively prepare for defense. So first, you have to be able to read it. I didn't wait anyway, so I started reading it, and we already complained. I'm making enemies against from the translator, I hope not. So I start reading this to see, to my great surprise and dismay, that it's heavily patched with black stains of redaction, which render most of it completely ununderstandable. So we have raised those issues. And we are, I suggest, I'm recently into the case, but believe me, I'm trying to catch up. Those redactions need to be reasonable. There are a lot of these redactions which I would suggest are not warranted at all. We have raised those issues in greater details yesterday. I'm not going to rehearse them again, but I think the redaction, first, you need the material to read it. Second, you need the material to be accessible and understand. Then after that, what you do? You go and you investigate. Why I'm saying this, I just want the court to appreciate how we are retained and not in an effective way, and how we are impeded in effective trial preparation. Because you read the statements, and of course they mention names, they mention places, they mention dates. You want, as a defense counsel, you want to go on the ground and check and verify those things. As it's done before this court, it's always very, the accusations are always very factual. So because of that, I would suggest to you, we are taking too much time, and we need a more candid and a more transparent prosecutor to allow us to advance and to finally say at some point, now we can say we're going to be ready there and we can start. And this explains why this motion for temporary stay that is pending before you. Because what I suggest is that without the evidence, without the identity of the people who are going to say these bad things about my client, how am I supposed to prepare? How am I supposed to assess and check whether these people are truthful or not? And this dwells onto the issue of this case arises from the Ngirabatoye case. So to give us bits and pieces of that procedure is not productive, I would submit. I know there is pending litigation, but in the same manner as you need to have to comprehend where the context in which the current procedure is taking place, by giving us, just for example, the witnesses testify on certain allegations on which there are other prosecution witnesses and defense witnesses speaking. And then the trial chamber in Ngirabatoye makes a thorough analysis of what took place. And we're given, a bit like you're doing carrot exploration in the north, you know, trying to see, to measure the age of the ice shell. It's not efficient. We are officers of the court. We can be trusted, and we can be provided with material in a much more generous fashion than what has been taking place so far, in my humble opinion. So the redactions, the protection measures, which are all excessive. I think the novel feature of this case, when we compare it with what was taking place back then at the ICTR, is all this electronic material. As I said yesterday, I will repeat this. I cannot accept that electronic evidence is born out of spontaneous generation. There is a history which allows you to know how it was obtained, in what circumstances it was obtained, and whether you can rely on it or not. At the moment, it's spontaneous generation. We have no idea who did it, when, under what authorization, whether it's legal or not. There is nothing. And we announced yesterday that there will be upcoming litigation about that, and we filed something which unfortunately has not been distributed yet, but we filed it during the night last night. I think it will make our position on this issue more comprehensible to the prosecutor and to the trial chamber. And this, of course, as my colleague said, all of these impediments to a swift and expeditious trial preparation has an impact on provisional release. How come these people are still detained today, when we are not even able to be satisfied, because of what I just mentioned, that we can have a proper trial date? This is not acceptable. And I would request the prosecutor to help us in that endeavor. If he's not opposed to the people being released in Tanzania, there are safe houses here. We know how they have access to the facilities, and so please be not only more candid but also more cooperative as your role of an officer of the court. So I would suggest that we could get more and expect a little more cooperation from the prosecutor to assist us on that. Where if these persons could be on a safe house in Arusha, I think it would be in a temporary acceptable solution, and I would really. I think that we really need to, and as my colleague Mr. Roberts has said, we need to insist on that, and we need for that to take place right away. And this will also facilitate their preparation, because now they are blocked in any possible manner. They don't have anything. At least they will have more time, and they will have somewhat more liberty to devote all their time in preparing their trial. So these are the issues I wanted to raise. I thank you for your attention, Mr. President.
Thank you, Counsel. And I turn to Counsel for Mrs. Fatuma.
Thank you, Mr. President. When we left one another at the last status conference, several measures were already taken by that time to solve a certain number of questions that have been raised by my learned friends. Among these problems and questions, there was the matter of communication or disclosure, as has been mentioned by my colleagues, Mr. President, and it would appear that to date, my client is not having disclosure of the material elements which will enable her to prepare her defense. Amongst those elements which should be disclosed to her are the possibilities of having access to the Ngirabatware case file, and which is the mother file at the basis of the difficulties that my client is facing today. You will realize, Mr. President, that in respect of Ngirabatware, he is able to access my client's case file. Why is there no quid pro quo that what is happening to Ngirabatware be able to be allowed to my client? There's no need for her to be getting partial decisions. We need to have full and complete disclosure. We would wish, Mr. President, that this matter be resolved. We welcomed the intervention of the judicial decisions which were taken in respect of the indictment, together with the matter pertaining to joint criminal enterprise concerning contempt of court, and also in respect of the matters of form which vitiated the indictment. We know very well, Mr. President, but we hope that measures will be taken in respect of other motions that have been presented and by my learned colleagues and friends. Mr. President, at the last status conference, all measures were taken to ensure that all these matters are resolved. Measures were taken, I say, but we have noticed that there is a date which I consider to be a bit sinister in respect of my client, and that is that of the night of the 7th to 8th February. During that night, our clients received a visit from certain institutions without notice. They were searched, their goods and materials were seized, some were even put under seal without the defense having been able to be given reasons for that situation. Since then, Mr. President, Your Honor, our clients are deprived, as our learned friends across the way have said, of all their working documents which were in their possession, without being able to prepare for the trial and respect the timetable which have been submitted to us by your colleagues. We would wish, Mr. President, that this matter be resolved, and the same goes for...
Judge Johnson, excuse me. If I may just, excuse me, Counsel, if I may just intervene a little bit. I'm just worrisome that this topic may be a bit problematic to...
I think only the source of the decision that is being challenged is confidential.
Okay.
So as long as you don't reveal that, you can continue.
I would like to continue in public session to once more talk about this situation, which appears to be very painful. I would like to lay emphasis on the fact that this situation doesn't enable my client to properly prepare her case. We still feel that the serious problem of translation has not been addressed. We filed a motion, Mr. President, during the last status conference. You took a decision requesting the facilitation of translation for our client in the language of her choice. On the 28th of December 2018, the registry wrote stating that translation could not be limited to the indictment and other documents for the registry. As far as we are concerned, we do not share this position. You would observe, Mr. President, that we tried to draw up a list, and we observed that out of the 282 files on record that were given to my client, 126 were translated into Kinyarwanda, the language understood by my client. Since January the 1st, only 3 documents have been translated in relation to decisions that were taken since January. These decisions are very important. I would like to point out, Mr. President, that till date, in view of the impediments faced by my client is unable to understand the purport of the documents. Whenever translations are sent to my client, they are sent 3 weeks or even a month after you've taken decisions on the subject. And you note, Mr. President, that this doesn't enable us to prepare our case, and that is why we filed a request, Mr. President. And since that motion was not addressed satisfactorily, we are requesting that a decision be taken and handed to the registry to ensure that all documents are translated and handed to my client to enable her to properly prepare her case and follow what's happening. And that would enable my client to benefit from a fair trial. We have other problems regarding conditions of detention. These problems are related to communication. These problems have been raised, Mr. President, until date. They have not been addressed. We would wish that they be addressed in order that communications be properly followed up so that my client can properly prepare her case. That would enable us to properly prepare our case. Mr. President, I align myself to what my colleagues have said on the same issues. I would therefore insist that there should be more diligence on the part of the prosecution with regard to the communications issue. This would enable my client, Mr. President, to respond to the requirements made in Article 69. Mr. President, I thank you for your kind attention.
Thank you, Counsel. Turn to Counsel for Mr. Dick Prudence MUNYESHULI.
Well, while we share in the frustrations of a lot of our colleagues, let me wrap up with some positive news. In looking at the, I'm sorry, is this good? How about this? Okay. No, you're fine. I just wanted to wrap up with some positive news. I was in conversations with Mr. Rashid. I read their reply. There's been some pending litigation about my client's laptop that was seized, and I'm pleased to report that we've got an agreement that my client can get a mirror image copy of that from the registry. So I did want to make that known, that that's going to help further things along. The quicker perhaps the court can authorize the registry to release that mirror image, because we're in agreement that we can have it. That'll at least help us prepare a little bit, and it's actually news of an agreement. So to that end, to the extent the court would be willing to, authorize the registry to get us that mirror image of that laptop, that'll help us prepare our defense. And that's all I have to say. Thank you.
Thank you, Counsel. And I now turn to the prosecution to address the issues raised by the defense. Mr. Rashid.
Yes, thank you, Judge Johnson. Judge Johnson, we'll just start with Counsel for TURINABO, Mr. Bourgon. Mr. Bourgon complains about the redactions and says they're very heavy, and I believe Mr. La Rochelle also joined in with that particular complaint. The redactions are made to the disclosed material pursuant to protective measures that are in place in this trial. The prosecution does not elect to blacken everything voluntarily or because of fun. We do that to respect the orders that are in place and ensure that we are compliant with those orders. Recently, we have filed the harmonization protective measures motion, which was ordered by this court. And I believe pending that decision, that will impact the redactions that have been made, and we will comply with the order of the court and ensure that if the court orders minimizing the redactions, we will do that in accordance with that decision.
May I just say that I can't order anything unless I'm requested to order it. Thank you.
Thank you, Judge. In terms of the requests that the defense have made under Rule 71B, initially, Your Honor, the defense did not particularize why they were asking for certain things under that particular rule. The jurisprudence is quite clear. When they came back a second time and they gave us a bit more detail, we then looked into that and did meet those requests that they made. And I believe we've even gone above and beyond that now by providing even more information to them than what they were even requesting. Initially, all it amounted to by the defense was fishing expeditions with generalized terms and broad search criteria, which does not meet the requirements of that rule. And I think to answer Mr. La Rochelle, if he starts to read the case file that he has, he'll understand why the redactions are the way they are. Additionally, he asks to be trusted with the materials and that we should just give it to them unredacted. The reason why their clients are before this court is because they leaked confidential information when they were not supposed to. And so, yes, we will do our utmost on this side to ensure that we protect witnesses that come before this court. That is our duty. For most of the other complaints that we heard in terms of the access to materials from the Girabatore case file, the issues of provisional release that were raised, and the issue of translations that was raised by Mr. NDAGIJLMANA. All these issues are under consideration at the moment by this court or by the appeals chamber. We do not want to go into that. We will await the decisions to come out, and then those decisions will clear the air on most of the issues that were raised here today. I'm going to just turn to Madame Sogoite to just give you a brief on the disclosures that have been made to the defense, because I believe there was also complaints regarding how they have not received disclosures. We just want to put that on the record as to what it is and where we are with disclosures up to this particular point. Thank you, Judge.
Thank you, Your Honor. We just want to put it on the record that as we speak today, the prosecution has been observing all its disclosure obligations in as far as this case is concerned, and that in the dates between 21 September 2018 and today, all the material that is in the possession of the prosecution that is subject to disclosure in accordance with Rules 71A1 and Rule 73 and 71B have been disclosed to the defense. The only late disclosure of Rule 71A1, which is being done today, is on the basis of the fact that counsel for NDAGIJlMANA was recently appointed. And so today we had to re-disclose to him supporting material that had been disclosed to the initial counsel for NDAGIJlMANA back in September 2018 when all the supporting material was disclosed to all the counsel in the case. Some of the requests we have received from the defense are requests in as far as material that is covered by Rule 76 is concerned. Rule 76B obliges the prosecution to seek consent from whatever authority that provides us with material that assists us in conducting our investigations. And until we have obliged with the provisions of Rule 76B, we are not at liberty to disclose such material. So as we speak today as a prosecution, we have been obliging by all the rules that govern disclosures in this case. I thank you.
Madam, Mr. Roberts suggested that a deadline be set for your response to disclosure request. What do you say about that?
Yes, Your Honor. Thank you for reminding me of that. It's a bit of a surprising timeline, Your Honor, because the rules provide that for every motion that is being filed, there is a certain timeline within which the prosecution should respond, and that is 14 days. And the prosecution has been obliging to that timeline. And as far as concerns other requests which have been via letters, it is a little bit challenging for the prosecution to be obliged to respond within 2 days, particularly when you take consideration of the nature of the request. And I may say in this case that this has been request under Rule 71B, that we have had these complaints that we take forever to respond. And one of the complaints, one of the points being put on the record is that particularly when an answer is a no, the prosecution has to be able to respond within 2 days. That is not reasonable for the following reasons. Whether or not a response is going to be a no, the prosecution and its responsibility is obliged to examine the request in view of the rule under which it is being requested. We have to examine the materiality of the requested material to the preparation of the defense case. And if the materiality is not demonstrated, then the prosecution will respond accordingly. It is not because the response is going to be a no that the prosecution should be requested or should be expected to respond the following day without doing its due diligence of examining the entire material and the rule within which it is being requested. So it is a very unreasonable request for the prosecution to respond within 2 days to the defense's Rule 71B request. We will examine the material that the defense is asking for. We'll examine the extent to which the defense is alleging that it is material to the preparation of their case, and we'll respond accordingly as soon as we can. Thank you.
Thank you, Madam. I didn't know that it was a request for 2 days. I just noted it was a request for a deadline. Mr. Roberts.
I believe I had said a general request for a deadline and suggested I thought 2 days would be reasonable. Obviously, that's not appears to be acceptable to the prosecution, so maybe 3 days would be more reasonable. I note just by way of comparison, actually, at the STL there was a decision, I think it's an order on the work plan from, if my memory serves me correctly, sometime in October 2012, in which 5 days was the response time. There were many more disclosure requests. It was a much bigger trial, and yet the prosecution still managed to respond within that time, and if they didn't, then obviously we would seize the judge straight away. And if they needed more time to actually disclose the material, that's understandable, because obviously once you've taken a decision you can disclose. It might take you a bit more time to actually locate the materials that are to be given. But in order to take a decision, I would say that's actually quite quick. And these letters are not long. The letters that the prosecution are responding to are not massive novels. They're one paragraph. That doesn't take too long to write. And by way of an example, one request recently took 5 weeks to respond, to say no, and that's, quite frankly, not good enough.
Well, a 5 days rule would create problems with weekends. Can the prosecution live with 7 days? Unless there are some extraordinary circumstances.
Again, Your Honor, I will reiterate that it will depend on the nature of the request and the material which is being referred to. We are dealing with a contempt case here, yes, and on the face of it, one would say a contempt case is a very small case in comparison with other cases that were tried at the tribunal. But the nature of the evidence we have in this case is such that it's so voluminous and it needs to be examined meticulously before any decisions can be made. It's not a decision some of them are not decisions that we can just make lightly that, oh, because it's a minor request, we can just respond within 7 days. So as I'm on my feet right now, I'm unable to say yes or no, 7 days is reasonable, because really it's a case-by-case issue. It will depend on the nature of the request and how much it requires for us to examine what is being requested and what we need to establish to decipher whether or not, in our view, it is material to the preparation of the defense case. I thank you.
Thank you, Madam Prosecutor. We will work on some language that could take into account what I've heard here. Mr. Arusha.
If I may be allowed a brief reply to what my colleague just said. Quote, the prosecutor has complied with its disclosure obligations. Unquote. That's a tune I've been hearing for 18 years. And that's a tune we know has some difficult connotation when looking at past experience, when the same claim was made. And monumental blunders in terms of material that should have been disclosed was later inadvertently discovered. I can give you some quote from the Bizimungu and al. Trial, where a prosecutor acting in 2 successive cases was severely blamed by the trial chamber after making that claim a zillion times before the trial chamber. So I will stop here, but I can say that we will litigate that. We disagree with that claim, and we will not leave it on the record that we are satisfied with the prosecution's claim, that they are cleared and they have complied with their disclosure obligations. Thank you, Your Honor.
Thank you, Counsel. Mr. Bourget.
Thank you, Mr. President. I do wish to reply to my colleagues' observations concerning redactions. It does call for a reply, Mr. President. My colleague says the prosecution does not elect to blacken pages and pages of evidence or something to that effect. Well, Mr. President, this is incorrect. And the best example I can provide you, Mr. President, is in its own filing on harmonized protective measures. The prosecution recognized that they had done redactions as part of the indictment supporting material out of an abundance of caution. And they recognized that they did not seek authority or obtain authority or had authority to put those redactions. And yet, we are now 6 months later, and we still have the same redactions in this material. And I will add to this, Mr. President, which I did not mention earlier, ex parte filings. We have made numerous complaints on ex parte filings. The prosecution has recently done ex parte filings in respect of this harmonized protective measures motion, which in our view was absolutely not needed, not warranted, and should not be authorized. And we certainly and respectfully ask upon you, Mr. President, to issue the proper order so that these ex parte filings do not, this practice must cease at some point so that we can work. And I just want to add one last part with my colleague who represent Madame Fatuma about the translation issue. He was referring to, of course, translations in Kinyarwanda. The same situation does take place and happen in French. We get many more translations than are made into Kinyarwanda. But the timing in which we get the French translations is making it very difficult, at least for my client, Mr. TURINABO. Thank you, Mr. President.
Thank you, Counsel. Any more observations? Yeah, Mr. NDAGIJlMANA.
Mr. President, I would like to correct an error which appears to be enormous. I talked of 282 filings on record. Out of the 282, only 26 were translated. I had the impression in reading the transcript that they talked of 126. As regards the issue of translation, I find it extremely important. The prosecution said these were pending problems that would be resolved. This kind of language is not acceptable. Mr. President, we filed a motion on this subject. And I would like the decision to be taken in the interest of my client. That is what I wanted to add, Mr. President.
That our language section works tirelessly, but we have staffing problems, and I will discuss it with the registrar, how to solve it. Now I turn to the situation and health of the accused. I would like to inquire whether any of the accused have a health concern that they would like to raise. If you wish, this discussion can take place in private session, or if you wish to raise a matter ex parte, I suggest that we consider it at the end of this conference. If we take the accused in the order they are in the indictment, Mr. Vagn, you have any issues?
Thank you, Mr. President. On behalf of Mr. TURINABO, there are no submissions regarding the detention conditions other than what I mentioned earlier refers with trial preparations. Thank you, Mr. President.
Thank you, Counsel. And Mr. Roberts?
Nothing from me, Your Honor.
Okay. Mr. Arusha?
Thank you, Mr. President. Mr. NDAGIJlMANA has nothing to add regarding this question. I would like to add that I understand distress endured by the clients during detention without being able to respond to issues concerning them. It doesn't assist them as regards their mental balance. They also have problems regarding their families. I think that in an ideal situation, remarks are necessary for us to properly appreciate the impact of the situation on the mental health of my client, Mr. President.
But please, you have the floor now. You commenced too early.
Course indulgence, Mr. President, as regards my client, Mr. President. I would like to say what I have to say in camera. I thank you, Mr. President.
So we return to you later, and first I take Mr. MUNYESHULI's counsel. Mr.
Your Honor, my client's very healthy. We don't like being in custody, but he's doing well.
Thank you. Mr. NDAGIJLMANA, are you requesting a private session or ex parte session to deal with Ms. Fatuma's health issues?
I think if we could go into closed session, it would be a good thing, Mr. President. Sorry. I prefer an ex parte session, says the client, Mr. President. That's.
I will excuse the other parties, and before doing so, I thank the parties for their cooperation in getting this case ready for trial. And we'll meet again in less than 120 days. Thank you. We'll just take a short break to clear the courtroom so we can continue with Ms. Fatuma. And to the public, the rest of the session will be ex parte, meaning that you cannot attend or be present in the public gallery. Thank you for your attention.
All rise.